Good evening and welcome, everyone. My name is Sue Fager. I'm the Transition to Adulthood Projects Coordinator for PACER. I'd like to welcome you to our training this evening, presented by Joe Kukla. And Joe and I were just talking before we started. Joe's been doing this training for PACER families for about 10 years. In addition to Jamie's announcement, the only additional one I will add is that the closed captioning option or feature has been enabled. So if you would like to access the training that way, you certainly can. Jamie, could you put up the next slide, please? Just a word about PACER for folks who aren't familiar with who we are and what we do. We are Minnesota's Parent Training and Information Center. We provide advocacy, training, and support for families who are navigating early childhood and special education services, and also after transition, navigating those adult services. All of our workshops and services are free for Minnesota families. And we provide support to families of children and young adults with any disability from birth to about age 26. So if you want to access our services, you'll find more information about us on our website at www.pacer.org. And with that, I'm going to turn it back over to Joe. Thank you, Joe.
All right, thank you, Sue. And I think what I'm going to do here is start by sharing my screen so that everybody can see the slideshow. But then also, yeah, as Sue mentioned, as an attorney, I've been giving this presentation once or twice a year for PACER for about the last 10 years. But this actually goes back a ways for us. We have a small firm in Edina. You'd call us a boutique law firm. But our specialty, besides the general practice of estate planning, and we do some real estate and small business work, we really emphasize working with clients, mainly parents, but also family members that have somebody with a disability. That's parents of children with disabilities, family members of people with disabilities. And so our primary focus is on dealing with guardianship matters, on dealing with trust planning, long-term asset planning as it relates to eligibility for Social Security and medical assistance, such as the waivered services. We also deal with housing issues, and so pretty much anything that touches the realm of the legal field related to people with disabilities, we're working on that. We have thousands of guardianship clients, well over 1,000 active court files with guardianship. And this goes back a ways. It started at this firm in the early 80s with an attorney named Bob Gunderson. And Bob was my parents' attorney. And I got into this because my youngest brother has developmental disabilities. And he is now in his, well, let's say he's going to be 38 this summer. And so he is under guardianship. He lives full-time in a group home run by Hammer. He has a job at Kowalski's that he has through Opportunity Partners in Minnetonka. And so I'm the oldest brother. I'm 8 years older than my brother Jake. And when my parents went through the guardianship procedure and set up their trust and their estate plan to make sure that resources and assets were protected for him. I was actually in law school at the time, and so I got to learn a lot from Mr. Gunderson as to how all of this works. I really became interested in his specialty in this practice and had no idea there was so much involved with like MA and SSI and all of that, which I'm sure, as parents, you experience that along the way as well. I just no idea there's so much to this. But that really kind of the work that he did inspired me to um, to get involved with this. And Bob actually passed away in 2009, and so a few years later, I decided to join this same firm. So that was in 2013. I became a partner at the firm in 2016. Uh, been here ever since. And currently, I guess the other things you should know about me is that I am serving on the board of Opportunity Partners. I've been doing that. I'm in my 9th year of that. And I am in, I think, my 3rd year of serving on the board of MAGIC, which is an organization well, MAGIC stands for Minnesota Association of Guardians and Conservators. So we strive to create sort of regulations, guidelines, performance standards for guardians and conservators in Minnesota. It's mostly tailored towards professional guardians, but certainly parents and family members can benefit from those resources and that information as well. So as we get into the presentation here, we've been doing this as a webinar since COVID, of course. The webinar we find works really well because we can reach a lot more people rather than having you guys all drive out to PACER and spend the night there. You can just hop on, which I appreciate you've done tonight. But because the effect of that is basically just me talking to myself the entire time, I do prefer and encourage questions as we go along. And Sue is going to kind of monitor those and edit and present those to me. I think what we'll do is address most of the questions at the end of each slide as they're presented.
Joe, if I could interrupt for just a second. If Jamie didn't already say so, go ahead and post your questions to the Q&A. Thank
Okay,
you.
perfect. So let's see. I've got to figure out how we can move the slides along. Oops, sorry. There we go. So when we're talking about guardianship, now, first of all, guardianship, the rules, the laws, these pertain to everybody in a lot of different circumstances. Now, we can talk about guardianship for an elderly person, somebody who has dementia or Alzheimer's and diminished capacity. We can talk about somebody who has suffered an injury as an adult and now needs help making decisions. But due to the fact that this is PACER, and I know the audience, will probably be mostly parents of younger children, that's sort of the way that this presentation is tailored to address the issues that parents are considering and confronting as their children grow up and become adults. And the way I sort of am presenting this is it's somewhat like a big consultation, so this is sort of how we approach this. If we get a phone call and somebody wants to meet with us to discuss guardianship, this is how we're going to approach it and determine what's the most appropriate way forward for you and your child. So with guardianship in general, what we're dealing with is somebody who reaches the age of 18. That's the age of majority in Minnesota. That is the age that an individual automatically is granted their independent rights as an adult. And quite frankly, as an American citizen, right? It's the right to make your own decisions as an adult and not have anybody tell you what you can or cannot do, within reason, of course. But when we look at this from the perspective of a person with developmental disabilities, you also look at it as when a person reaches the age of 18, not only are they granted individual rights and the right to make their own decisions, but with that also comes the responsibility, right? You have to be responsible for the decisions that you make. You have to be responsible for your own person. Granted, this is difficult for a lot of 18-year-olds, disability or not. Uh, but 18, it's a somewhat arbitrary age, but that's the age that we've selected, as being the age that turns, that everybody becomes an adult and becomes responsible for themselves. So what guardianship is about is declaring that a person who by diagnosis has a disability, and if they are left to take responsibility for their own decisions as an adult, that could make them vulnerable and that could make them subject to exploitation and they could be taken advantage of. And so we look at what are the ways that we can protect a citizen of our community uh, from those vulnerabilities as an adult. And so the first thing we do evaluate when a person um, is a potential candidate for guardianship is their level of incapacity. What is the diagnosis? What do the doctors say to the parents or to the family about the ability of this person to comprehend what we would call like adult decisions? So decisions about their health care, decisions about where to live, just in general, how to take care of themselves. What is their capacity to do that? And that's where the division comes with every other 18-year-old, because without a diagnosis of disability, sure, that an 18-year-old may be immature, they may not be fully ready for those responsibilities, but they have the capacity to become responsible, to take responsibility. With a person who has a diagnosis of disability, the argument is that they simply lack that capacity to appreciate or to understand how to take responsibility for themselves as an adult, and that's what makes them vulnerable. So that's part of evaluating the need for guardianship, but also in that process, when we first meet somebody, we're talking about, is guardianship actually necessary? And so we sort of look at this, and a lot of attorneys do, who practice with guardianship. And quite frankly, that's the way that the legislature wants us to look at it. And that's the way the courts want us to look at it, is guardianship is the action of last resort. It's something that we want to evaluate and determine if this person, once they turn 18, has some diminished capacity or there's a concern about capacity. Is it absolutely necessary to actually restrict their rights as an independent adult in order to protect them? Or are there alternative options that we could look into where it's a situation where the person who may need some protection, may need some help, as an 18-year-old, 19-year-old, 20-year-old, they might be able to have that set up by other ways. Again, a good way to sort of understand this by comparison is an older person, somebody who is reaching their later years, who has some diminished capacity. Do they just need a little bit of help paying the bills, understanding what the doctor says? And if so, can they give consent to another person to say, yeah, I need a little bit of help, but I'm still capable of making my own decisions? Um, we look at a person who's 18 or younger, maybe even in their 20s, um, the same way. Is this a person who needs to have their rights restricted, or are there other options that we can consider? And then just for the sake of it, I mentioned here, because the terms are a little bit confusing, and just to clarify, guardianship and conservatorship are not the same thing. Conservatorship, when we deal with that, we're talking about handling assets. We're talking about handling money. Whereas guardianship, we're talking about handling the person. Um, it, what that means is taking care of the primary issues that the individual faces for their personal care. Now, as we go along here, I'll explain too, mention this again, but um, guardianship does not, at least in the state of Minnesota, the guardianship statute does not include any financial authority for the guardian. You do not have the ability to control assets just as a guardian. You do have the ability to control benefits, which again I'll get to, but if a person has accumulated personal assets and those have to be managed on their behalf, then we're talking about conservatorship. It's rare for us to do guardianship and conservatorship for an 18-year-old, because usually an 18-year-old doesn't have their own personal assets. It is far more common with an older adult who becomes disabled. But just bring that up here so that you realize that there is a distinction between the two. Okay. And so one of the ways that we evaluate the need for guardianship, and what I find really effective in talking to parents to understand more about their child, is if we go through the statutory powers of guardianship themselves. And when we're dealing with the court, we are actually petitioning and asking that each of these powers be granted to the appointed guardian or guardians. And so the evaluation is really about whether the individual has the capacity um, to handle each of these things on their own. And so we start with the bare minimum. Like if there was nobody else in their life, would they be able to make decisions like this? But then from there, we sort of evaluate, well, is this a decision that they can possibly make if they have some help, if they have some assistance with that? But the other thing is that with a guardianship, each of these powers is granted individually. We have to explain to the court why each power is necessary for the person subject to guardianship. And one of the ways that we can look at as a less restrictive alternative to full guardianship authority is that we can, in our petition, claim to the court that there are some of the things on this list that are necessary for a guardian to have, but there are some things that the individual can retain the authority to do themselves. And of course, the list that I've got here on the slide is very abbreviated. If you read the statutes themselves, each of these has about a paragraph or two describing what they mean. So I'll kind of go through, and again, this is what I would do with parents who are meeting with me in my office to kind of explain what each of these powers are and flush out whether this is something that they feel like they must have this authority over their child because their child is not capable of exercising these powers. The first one, establishing a place of abode, that simply means determining where this person lives. And this is really about, if this person was left to their own devices, would they be capable of finding a suitable place to live on their own? Could they find an apartment? Could they find, could they purchase a house? Could they, find a group home, even if it was their own decision? And so this is often one where you say, that's a little scary thought as an 18-year-old, or but even as a 25 or 30-year-old, this could be a daunting task. So it's really about, what level of authority does the guardian need? Do they need absolute authority to decide where this person lives, or would it be a matter of just assisting a person in finding a suitable place to live? But then the second one, we're talking about just what it says there, providing for their care, comfort, and maintenance needs, making sure that this person as an adult has everything they need to live comfortably. And so, of course, this can be interpreted many, many ways. Um, it's in general, I guess, how we describe the guardian's powers, because overall, that's what you're doing. You're making sure that this person has everything they need to be safe and protected and live comfortably with their life. The third one, taking reasonable care of personal property, we usually deal with as a matter of uh, whether this person understands the value of things that they own, and whether they would be able to properly dispose of things that they own. So, if you have a child who's 15, 16, 17 years old, of course they have their own stuff, right? They have their own clothing, they have, maybe video games, they have books, they might have their own iPad, even a phone or something that everybody in the family considers their stuff. But ultimately, who can take responsibility for that stuff, right? If something breaks, would they know how to get it fixed? If they need to um, dispose of something by tossing it out or selling it, would they understand the value of it or what to do with it? But then also, would they be vulnerable, if somebody else asked them for their stuff, right? Like if your 17-year-old has a friend over from school and they really like your child's Xbox, is your child just going to give them the Xbox, right? Do they appreciate the value of that property that they own? Or as the guardian, do you need to have the ability to intervene and protect that personal property from somebody exploiting your child? When we get into number four, that's oftentimes the deciding factor when we're talking about less restrictive alternatives and we're talking about things that we can do to help somebody who may need some assistance as an adult. Um, there often is a dividing line when we get to giving consent to medical or other professional care. And oftentimes that dividing line is imposed by the doctors, the medical providers themselves, because one of the less restrictive alternatives that I'll really describe a little bit more in detail later is a healthcare directive. And that's a document where an adult can give another adult the consent to see their private medical records and make decisions for them. Well, if you have a child who has a diagnosis of disability and their doctors are of the belief or of the professional opinion that that disability is significant enough that that person lacks the ability to comprehend and give meaningful consent, then that doctor is going to declare that we can't allow this person to make decisions about their own care and their own treatment. We can't allow somebody else to do it just on the basis of that person's consent. So you need to go to court, obtain guardianship, and have the legal authority to see a person's private records, consult with doctors, and make decisions about their medical needs. So this is where we talk about, of course, we want a person to be as independent as possible. But here's a real example of where pushing independence can actually be detrimental. You really have to be honest about what the person's capacity or capabilities are, because if your child is 18 years old or 19 years old and you do not have guardianship, and and your child has to go to the emergency room, it's entirely possible that the medical staff, the medical providers at the ER will deny you even as a parent from making decisions or being involved in that person's care. And this goes straight to HIPAA and privacy rights. And so without a court order declaring that this person lacks capacity and is under guardianship, those medical providers are bound by HIPAA and have to um, honor that person's privacy rights. So there is, you know, not to frighten or too much, there is some nuance to that. I'm aware of a lot of people, a lot of parents sort of successfully convincing doctors that their child, needs their help and that there's not going to be a problem if they see medical records. Uh, this often happens, of course, if you're seeing a doctor who has known your family that for years, has known the relationship that you have with your child. They're not going to be terribly cautious or concerned about revealing private medical information. But you don't know that for certain if you're seeing a specialist or when you transition from pediatric care um, to general care. And so it's something that, again, it can often be determinative of whether guardianship is necessary. And once again, when we're evaluating the need for guardianship and we're looking um, at the least restrictive options as possible, one of the things that is possible is to petition the court and ask for specific powers. So oftentimes, if we do that, we call that a limited guardianship. We will most often ask for this fourth power. A lot of times we'll ask for the first power. Um, and then as you get along, you'll see like the fifth power, the seventh power, those are also important ones. So that fifth power, what this means is that we're protecting a person from being taken advantage of. So approving or withholding approval of any contract does not mean that a person subject to guardianship cannot enter into a contract. They can sign an agreement for like a cell phone. They can sign an agreement for uh, a credit card. They can sign a lease agreement for an apartment. what this power is for the guardians is it gives them the ability to void any contract of that nature that they feel was exploitative, that they feel like the person subject to guardianship was being taken advantage of in that deal. So this doesn't come up terribly often, but we do see it, um, say for example, your child has an Amazon login or has the ability to know what yours is, and goes on to Amazon.com and orders up a whole bunch of stuff and purchases and everything, uh, and then you find that out later. Well, it's legally, if you have guardianship, you could void that contract. You could void those purchases. We have had this come up with credit card companies, because that's primarily, I guess, what it goes through. They're using the credit card that you have on file, and they're making purchases. And um, I'll just say it's a lot easier dealing with those credit card companies than you might expect, because they understand what the rules are. And if you provide them with proof that this is a person subject to guardianship, you can protect those sort of vulnerabilities by explaining to American Express or whoever that um, that these were not that I, as the guardian, do not authorize these purchases, and you can void that agreement. So again, just a way to protect this person from being exploited. It's also, again, if they go to the mall and sign up for a phone at a kiosk, you would have the ability to void that contract. Um, the next one, exercising supervisory authority. This is somewhat similar to the personal property. With supervisory authority, what we're thinking about is a person's relationships. If they certainly have their own friends, they have their own uh, personal contacts that they have, and that may be even like through social media. If they have a phone or they have an iPad, they might have Facebook or the different social media accounts where they're interacting with people. And being subject to guardianship doesn't prevent them from doing that. And as a guardian, you don't have to stop them from doing that. But you could retain the authority to exercise supervision over those accounts legally, supervision over those relationships legally, so that if you do detect that your child or the person subject to guardianship may be being taken advantage of, or may be um, being exploited, then you can intervene and prevent that from happening. And that can come with restriction of who they can interact with, but also as far as exercising your authority um, to prevent that other person from contacting the person subject to guardianship. As I mentioned before, number 7 is another big one that we always analyze, the ability to apply for government assistance benefits. This also includes the ability to manage government assistance benefits. This is often another one that determines whether guardianship is necessary or not. Because if you're going to apply for waivered services through the county, it's the expectation is that if the person is not subject to guardianship, that they are going to handle that process themselves. This is even more strict if you're dealing with the Social Security Administration. If they do not have proof that the person is subject to guardianship, they will operate as if that person has the capacity and the ability to deal with their benefit application, and any issues related to eligibility or suspension of eligibility, or reporting of assets or reporting of circumstances, they're going to expect that that person is able to do that themselves. So again, it's the guardianship is you establishing or proving otherwise that this person needs help and cannot manage their government assistance benefits on their own. The other thing with that is, again, we talk about with a less restrictive alternative, we talk about maybe a financial power of attorney helping in a lot of situations, but that has no effect on the government assistance provided through the county, which again, I'm talking about medical assistance, which is Medicaid. I'm talking about waivered services. It also, a power of attorney executed under Minnesota state law is also generally not accepted by the Social Security Administration. So those less restrictive alternatives may not be sufficient if you're dealing with the Social Security or medical assistance and your child is not able to speak for themselves or navigate that for themselves. Number 8, establishing an ABLE account is not something that I really want to get too deep into. That's something that could be a presentation all to itself. And I don't, if a lot of you were attending last Monday night's presentation about the financial resource planning, I'm sure, I know that that was discussed a little bit there, but basically ABLE is an option for a person who has assets, but also has asset limit issues for the eligibility for their government assistance. It's a way that a person can preserve assets and remain eligible for those programs. Well, the guardianship statute in Minnesota will give guardians the authority to establish an ABLE account for that person so that assets can be transferred and government assistance eligibility can be preserved. So just know that that is something we often ask for if we are filing a guardianship petition. Even if at the time the person does not have any assets, we anticipate that it's entirely plausible or even likely that that utilizing an ABLE account will be something that is appropriate or necessary in the future. Then the last one, representation in court proceedings. What we're talking about here is basically being a proxy for a person. If they are involved as a party in a court procedure, this would be civil or criminal. What I want to emphasize, because I do get this question more often than I ever anticipated, really, is but if you are a guardian of a person, you are absolutely not responsible for any of their actions. You're not responsible for, if they are accused of any wrongdoing, and that could be something like theft, that could be something like assault. If that happens, you can represent them as far as a court proceeding is concerned. Like you can take their position in the courtroom and for the purpose of understanding and helping them understand perhaps what is actually going on in this procedure. And of course, they would have a lawyer and be represented that way. You're not required to make arguments for them, but this just gives you the opportunity to sort of to be involved in that procedure and make sure that they understand everything that's going on. But in no way do you say inherit any responsibility. If it is a situation where there's a claim against them for monetary damages, as a guardian, you are not responsible for those damages, but you can help and have standing to assist in the court procedure. That's basically what that means. Okay. So, how are we doing, Sue?
We have questions, Joe.
All right.
So here we go. Does your firm charge for guardianship for a minor? And when is the best time to start a guardianship application for a child who is 17 years old?
Yeah, so that is something that I get into a little bit in the next slide. But I'll just answer briefly. Yes, we do charge a fee of the petitioners. It's a flat rate fee. We do it because the county does not compensate the attorney at a rate that is anywhere sufficient to cover our costs, even in preparing documents and preparing the case to go to court. I guess what I'm speaking of primarily would be like Hennepin County, Ramsey County, Dakota County. Now, there are some counties, I would say Anoka stands out, Washington County stands out, where they provide more compensation to the attorney who's representing the petitioner. And so we sort of adjust our fees based on that. But if we did not charge fees privately, we're not a nonprofit organization. We're not a subsidiary of PACER. We simply would not be able to provide the service because we have staff that we pay to produce the documents, and we have all of our time spent in preparing the case and representing the petitioners at the hearing. Um, so there is a
Joe,
combination of trying to use the money that's available to us from the county and charging a fixed rate from the parents or the petitioners.
how would a family go about finding out if their county provided some financial assistance? Would that be the county case manager? Would they call the court? Would they figure that out?
It is a good question. I'm not sure if the court would divulge that information because the basis for that relief is, and again, I'll get into that on this next slide when I'm talking about the court procedure. You see down there towards the bottom, cost. The phrase is in forma pauperis, and that's Latin for this person doesn't have any money. Okay, and this is a concept that isn't exclusive to guardianship. This is for any civil procedure. This is if a person has to go to court, if this is a necessary court action and they don't have the money to pay filing fees, they don't have the money to pay for representation, they don't have the money to pay the court admin costs, we can petition the judge to grant relief by in forma pauperis. And we refer to this as IFP for shorthand. And so a lot of times, I do hear from people saying that their case manager or their social worker, somebody told them guardianship is free. It's not free. It's never free for anybody. All that means is that the county has given its approval, has evaluated the person's assets and capability of paying for this procedure, and then has deemed it a necessary procedure and has decided that they will cover the costs of going through this procedure. So when we file a petition with the court for a guardianship, we generally also file a request that the court grant in forma pauperis status to the person subject to guardianship. And what that does is that allows the county or orders the county, I guess more accurately, to pay the filing fee, which is $300 roughly. I think it's $297 is the actual, but then um, it also would pay for the court-appointed attorney who represents the person subject to guardianship, and it pays all the other administrative costs of the procedure. So we've estimated that to be as much as like $1,800 or $2,000 in fees by the end of the procedure. And so this is a great relief, and we ask for that. But in only a few of those counties do they also compensate the attorney for the petitioner. And when I say the petitioner, I mean that's the parents who are petitioning the court asking for guardianship. And so that is why we have to, in most cases, especially around Hennepin and Ramsey and Dakota County, and that's why we ask for a separate fixed rate fee, which we believe, in comparison to most other lawyers or law firms that offer these services, that our fees are pretty modest, and certainly competitive. But that's the reason for it. So I guess we call it sort of a hybrid approach to dealing with the expenses.
Okay, thanks, Joe. Someone would like to know if they should consider guardianship for medical now, because healthcare professionals are blocking records at age 12 in Minnesota, even if the child has signed healthcare proxies.
And so I guess that gets to the other question too, about when it would be appropriate to begin the process. Number one, just as a lawyer, that doesn't pass the smell test to me, because the reason why we don't go through this process for a person until they turn 18 is because prior to the age of 18, the fact that the person is a minor is, by legal definition, an incapacity. And so the difference is that as a minor child, parents automatically have that authority as the decision maker. So they are guardians, technically under the law, until their child turns 18. So the fact that medical providers are withholding information from parents, if that's the case, that's what doesn't pass the smell test for me. That's where you really should talk to a lawyer who deals with not necessarily the guardianship issues related to disability and related to guardianship as an adult, but you may really have a more of like a medical malpractice issue going on there. I can't understand, unless we're not talking about parents who are asking for this information. I can't understand under what law, rule, or what justification those medical providers would have or withholding records from parents. So that's something that probably needs to be looked into a little bit more. As far
Okay.
as then leading into when a person or when parents should begin the process of applying for guardianship, is like, I suppose we'll look at it this way. Right away, when the person turns 18, they are granted those individual rights. There's an expectation of independence at 18. So the courts, at least in Minnesota, are allowing the petitions to be filed when the person is still 17, even though you're declaring in the petition that this person is an adult and without guardianship they would be vulnerable. Well, we usually have people start that process about 3 months prior to the 17th birthday. The reason being is because from the date that you file the petition to the date of hearing is, in most counties, going to be a period of time of about 6 to 8 weeks. And that is entirely due to the court calendar and their schedule. That's basically how far they're backed up. There's also notice requirements. This is a matter of due process for the person who's turning 18. That's why they have their own court-appointed attorney. They have rights, right? They have the ability to object to this petition that is being filed. And so part of the process is giving notice to that individual. You also have to give notice to anybody else who has standing under the law to be able to object. That primarily would be immediate family members. And so that would include any siblings who are adults. So anybody who's over the age of 18, that's a brother or a sister, has the legal standing to show up in court and object to that petition that's been filed. So because that process takes a little while to play out, the general sort of advice on that is that if you don't want there to be any issues with a gap in authority, you should start the process, at least initiate things with the attorney, maybe about 4 months, 3 months prior to. But there is a limit to that. I think if you get a little even like further than 4 or 5 months prior to the 18th birthday, the court is simply going to reject the petition because they'd say that this person's not an adult, they're still a minor. The subject matter fails here. We can't grant this petition, we can't issue an order. So there is a bit of a balance there, but as long as you initiate the process about 3 or 4 months prior to the person turning 18, you should comfortably or feel comfortable about having a court appearance and an order before that person turns 18.
Joe, we've had a couple of people ask about guardianships established in one state and then the guardians moving to a different state, or
Yep,
the person moving to a different state.
sure. That happens, with us, every year we have probably half a dozen or so, people move away from Minnesota or move here from another state. And there is a uniform process. Frustratingly, the acronym is, you can't remember it. It's like UCGJAT something. It's basically the Uniform Guardianship Transfer Act. And most states, over 40 of them, participate in this. If they do not, we have another procedure basically to terminate and reestablish. But for the most part, those guardianships are transferable. We get a court order from the state where they're moving from. And so in the case of somebody moving away, we would get a court order from Minnesota saying that moving the guardianship is appropriate. The family has established that there will be a new permanent residence for this person. And then you contact you have an attorney on the other end, either in the new state that they're moving to, or we would be that attorney in Minnesota taking the information from the state they're moving from. And we just work through the court process with that. Generally, there would be no hearing. Sometimes that is required. Some courts like to just review and make sure that guardianship is still appropriate, but it's simply a procedure that we go through to make sure that the authority of a guardian is established in the jurisdiction where the permanent residence is. Now, that also kind of brings up, if you do go on like a vacation, even if it's a longer one, if you spend a month in Florida with your person subject to guardianship, your Minnesota guardianship still has authority there because you haven't established permanent residence in Florida. So you don't have to worry about, getting like a proxy guardianship or a temporary order or anything like that. Your authority as guardians granted by the Minnesota court is effective if you travel. So, I know we've already kind of been at this for an hour, so I'm going to kind of expedite what we're dealing with in these slides. But what I've laid out here is the procedure for the court. This is if we engage the court with a petition. Basically, we're explaining to the court uh, why this person needs guardianship and why the petitioners are the most suitable people to be the guardians. And a lot of times that's an easy answer. These are the parents. They've always taken care of this person. They should be the guardians. But a lot of times it's not parents, and we just have to establish why this person is the best person to be selected by the court to have the authority to supervise this vulnerable citizen in the community. And I guess, when you get to the heart of it, that's really what we're doing, and that's why parents even have to go through this process. Is here we have an independent person who is living in the community. It's the court's responsibility to make sure that this person is protected. And so when the court appoints the parents as the guardians, they're saying to the parents, we believe you are the best people to be our agents. You're the best people to represent the court and take the responsibility for protecting this person in the community on our behalf. Because of that, one of the requirements, and that's down at the bottom here, the annual filing requirements, you have to file a report with the court every year explaining how things are going. We call it a personal well-being report. This is so the court can keep tabs on everything. This isn't necessarily to meddle in your family dynamics um, or really to interfere with you. It's simply to make sure that this adult citizen that they have responsibility for because they've determined he or she is lacking in capacity and may be vulnerable. They have a responsibility to make sure everything is going okay. And so that's when, parents, it seems, maybe silly or even intrusive, but you have to file these annual reports with the court to make sure that everything is going okay. If you don't keep up with that, the court will take steps to make sure that everything is okay, including sending, say, like adult protective services to do a checkup, to do a welfare check on the person and make sure everything is going okay. And if they continue to not have any response or any interaction with the guardians, they will call them into court. If the guardians don't appear in court, the court can issue a bench warrant stating that they are in contempt of court. And at the most extreme, they can remove the guardian from that position for cause. And so even though, again, it might seem intrusive, why do we have to explain to the court what's going on? It all comes back to this idea that this is an independent adult. You are filing a petition with the court explaining that if this person as an 18-year-old, a 19-year-old, or 20-year-old is left to their own responsibilities, they're going to be vulnerable. So we're asking the court to grant us the authority to take responsibility for them. By doing that, the court has a responsibility to keep track of what's going on and making sure that that vulnerable adult is safe. Part of the process, again, in determining whether guardianship is appropriate then is we usually ask for a statement from the person's primary care doctor, and we submit that as evidence supporting the petition. There is also going to be a court visitor in this process. A court visitor is generally a social worker who is employed by the court or by the county. And their job is to meet with the person subject to guardianship and make an independent evaluation of the need. And so they come out, they do an interview, and then they write up a report that is submitted to the court file. And hopefully that supports the petition and the need for guardianship. But kind of the idea is we're not just taking the petitioners at their word. We have somebody else evaluating the situation and whether this is appropriate. And again, as I mentioned before, the court-appointed attorney, you have the person subject to guardianship has their right to counsel in due process. And so that's another check to make sure that this is absolutely necessary and appropriate. Oops. A criminal background check, well, what that is a person who's going to petition to be appointed as a guardian. Of course, we want to know what their criminal history is. Now, that is going to be something that if a guardian is appointed who is, like, say, a brother or sister or a professional, they're going to have to submit consent to a new background study every 3 or 4 or 5 years, depending on the county. In Hennepin County, it's every 3 years right now. This is something that, like, if I were to petition to be appointed as the guardian of my brother, I would have to submit to that every 3 years because the court just needs to verify that. Now, there is a part of the statute, though, that says that if the parents are appointed as the guardian or one parent is appointed as the guardian and their child has always lived with them and been under their direct supervision, that the court has the authority to waive the background study requirement. And so that's something that we always do. We ask the court, if we're petitioning on the behalf of the parents, we ask that the court waive the requirement for the background studies, and it's usually not a big deal to get that granted. There is an educational video that the state of Minnesota produces and makes available for people. They do really encourage potential guardians to watch this. It's useful. I think the feedback I get from a lot of parents is that they appreciate it because it does a good job of explaining the difference in their role between parent and guardian. And so that's something that if you just Google Minnesota guardianship video, you can find it pretty easily. It's also just on the judicial branch website. I mentioned the court hearing itself is a matter of proving the petition, establishing that guardianship is necessary, and that the petitioners are the most suitable people to be the guardians. And then that last one on the bottom, the renewal for a person subject to guardianship under the age of 30. One of the parts of the statute in Minnesota is that if we have a court order granting guardianship of a person who is not yet 30 years old, is the term of that order can be no longer than 72 months or 6 years. So what that means is that basically the legislature has decided that people who are turning 18, maybe by the age of 24, it's just a matter of slow development. At 24, they may be more capable of independence. So it sort of automatically forces us to reevaluate and look at whether guardianship remains necessary. So parents who are petitioning to have guardianship of their child at age 18, you just need to be aware that your guardianship authority will expire automatically after possibly 6 years. It could be shorter, but generally we're talking about 6 years. And you just need to be prepared that at that time, if guardianship is still appropriate, you're going to have to petition the court again and essentially establish why guardianship is necessary still going forward. And we try and keep track and alert our clients when that term expiration is coming up, so that we can get ahead of the petition and get that filed. So again, that there is no break in that authority. Are we doing okay, Sue? You have questions or anything?
We have questions, but why don't you do special considerations? I want to make sure you have enough time to cover all the information.
Sure, that sounds fine. And if we get to the end and I still have questions left, I'm willing to stay a little bit past 8 o'clock just to get those answered. And I don't know if you are, but we'll see how that goes. So the special considerations, these are just other things that we have to think about as we're going through a guardianship petition. The right to vote. A person at age 18 generally can register and have the right to vote. We can preserve this right even for a person subject to guardianship. And in fact, in most cases we do, unless the person's disabilities, their diagnosis is really profound, where they really have such low capacity cognitively that they will never comprehend the voting process, who's running for election, anything like that. And then where their vote could be something that could be exploited. So, but generally speaking, we're going to ask that the right to vote be preserved. And it doesn't matter whether they ever exercise it or not. 50% of eligible adults don't vote. So, but what we're talking about is just preserving their right and their ability to do that if they are capable. When we were talking about medical procedures and giving consent and seeing records, uh, there is another level to that, and that's experimental or extraordinary medical procedures. That's just not automatically granted to a guardian. A primary example of this would be like sterilization. You cannot simply decide as a guardian to sterilize the person subject to guardianship. Understandably, it's for their own protection, for their own health. But an extreme procedure like that requires additional authority, and what that means is a separate petition to the court. And in that petition or in the statute, the law requires you to get two independent opinions from doctors that are in agreement that this procedure is necessary. So that's just to make you aware that if a guardian is appointed, their medical decision-making authority does not extend to every procedure. There are some extraordinary circumstances. The Bill of Rights for persons subject to guardianship or conservatorship, I do have a couple of slides on those and I'll show you, but this primarily what I'm pointing out here is for the first hour here, what we've been talking about is how we restrict a person who has a disability. How do we have their rights sort of transferred to another person of authority and restrict their individual rights? Well, the legislature and all of us involved in the court process very much want to remind people that there are still a lot of rights that people subject to guardianship have. And so I'll quickly sort of go through those in the next couple of slides. Another consideration that we often come across is what do we do about guardianship of a person who has divorced parents? And what I want to explain here is that if there are decisions that are made in the family court regarding custody, regarding parental rights, visitation rights, or the opposite, restrictions, the guardianship procedure occurs in the probate court. And the probate court judges are prohibited from making decisions that overrule or contradict what has been decided previously in the family court regarding custody rights and things of that nature. So divorced parents absolutely can be co-guardians. The requirement by the probate court, though, is that they are able to work together, that they make all decisions collectively. The court with a guardianship will not tolerate one parent being the guardian while they have their child visiting them and the other parent being the guardian when their child is with them. If there are decisions to be made about like medical treatment or about where the person lives, or dealing with, say, personal property, things of that nature, if even if there is a division in the marriage and a division in custody from the family court, the probate court for guardianship expects that those co-guardians are going to make decisions together and they are going to make decisions unanimously. And so what we have to deal with is the idea of whether or not we think that divorced parents can get along well enough for the sake of their child that they can work together as a team to make decisions and not argue, because it's not always perfect, of course. And I will tell you what generally happens. Number one, this is the biggest reason we end up in litigation over guardianship, which is something everybody wants to avoid. But number two, if the probate court cannot determine whether one parent or the other is more suitable. Say, you've got two good parents who simply can't get along, and they can't make decisions together. Well, what the court is looking at is what's in the best interest of the person subject to guardianship. And so rather than giving each parent sort of shared rights as a guardian, the judge will simply say, you're both out. I'm going to find a third person, or we need a nominated third party to be the guardian. And that may be a professional, that may be another family member, but the probate court is uninterested in your disagreements as parents. And they don't have to adjudicate that. If they don't think that you can get along, they don't care what the reason is, they're not going to grant guardianship to you. So that's something that you have to keep in mind if you happen to be divorced and if you happen to have that issue come up. So again, it's a special consideration that we deal with in the course of this procedure. Okay, and again, as I mentioned, the Bill of Rights for a person subject to guardianship. This is something that I don't have to go through each of these. You guys can read these and have the handout. But in general, you can see we're trying to recognize that there's a lot that a person subject to guardianship still has the right to do and still has independence for. And these are not absolute authorities. Like, they're granted due consideration of their desires. They're not to receive medical treatment in violation of, let's say, religious beliefs. They can help themselves to their own care, comfort, social, recreational needs. But again, these are balanced with the authority of the guardian, because the guardian is in a position to protect them from where they might be vulnerable. As this goes on, here again, it gets a little bit more direct, where it says that a person should be consulted and, to the extent possible, help to make decisions about the care and disposal of their personal property. They get their rights to personal privacy and personal relationships unless the guardian has good reason to believe that restriction is necessary. Number 11 is one that comes up more often than you would think. The person has the right to marry and to have children, right? We don't take that away just because they're subject to guardianship. I know plenty of people who are married and living in group homes. Whether they live in the same group home, that it may not be the circumstances, but certainly we are not automatically restricting their right to marry or to have children by this procedure. It also means that a guardian cannot automatically nullify a marriage. That comes up too. The idea that mom and dad don't approve of their child's choice in partner is nothing new. That's nothing unique. But the guardianship does not give you an extra tool or an extra way to object or to interfere with that marriage. You really have to show that that this person causes or poses a significant physical, psychological, or financial risk, and is in a position to take advantage of the person subject to guardianship. One other thing here too is that a person subject to guardianship, if they believe that they are capable of independence, they have the right to petition the court to hire an attorney and request that the guardianship be terminated at any time. Now, they carry the burden of proving that petition. They carry the burden of proving that guardianship is no longer necessary, but it is a right that they retain if something like that may be possible. On the bottom, just noting a couple of parts of the statute or the Bill of Rights that are a little bit more recent, and so that has to do with social media, executing a healthcare directive if a person is subject to conservatorship but not to guardianship. So having assistance in making healthcare decisions if there is not a guardian appointed. Okay, and so my last slide here is just making you all aware of what we consider when we're talking about alternatives to guardianship. And again, the approach that we take and the approach that most of my colleagues or contemporaries take if they practice regularly in the field of guardianship is to first flush out these ideas of alternatives. And is this at all possible? Now, granted, that certainly depends on the diagnosis. If we have a person who is profoundly disabled, who is nonverbal, who is non-ambulatory maybe, and it's clear that they are extremely vulnerable as an adult, we don't need to spend time discussing these alternatives. But for a lot of people, particularly with an autism diagnosis or Asperger's, or even some people maybe with Down syndrome, there is a discussion that we would like to have about perhaps alternatives to that restrictive authority of guardianship may be possible. And there may be ways to provide assistance to a person as an adult without going to court and having rights restricted in the sake of protection. This is also, quite frankly, one of the ways that we can determine whether guardianship is appropriate. If it is questionable, or if it is something that parents think like maybe it's possible, we can try for a period of time utilizing a healthcare directive. We can try utilizing a power of attorney. Like I said before, you'll know definitively if that power of attorney or if that healthcare directive is rejected or denied by a person in a position of authority who says, I don't believe that this person had the capacity to execute this document or to give meaningful consent to the powers that are granted here. But if there is, some elevated capacity and the person is just slower developing and is a young adult who just needs some assistance, utilizing this form of consent is the most appropriate way to sort of support them as an adult and prepare them for independence. Now, this is where I would also say that every 18-year-old should have a healthcare directive, because if you get in an accident or if you're sent to the emergency room as an adult, not even your spouse has the legal standing to see your medical records or see or make decisions for you, and certainly not your parents. And so it's a good idea for anybody to have a healthcare directive. It's a good idea for anybody to have a power of attorney just in case. But in the scenario where we've got a person with disabilities, these may be on point documents that could really help them and support them as independent adults. Um, the idea of limited guardianship is what I was talking about earlier, is we can be selective about the powers of guardianship. We do not have to have a full statutory authority guardianship. So that's another thing that we look at as a way to be less restrictive, and maybe have the person subject to guardianship reserve some powers for themselves. At the bottom here, I'm simply listing some additional resources that people can use to find other ideas and other ways to consider alternatives to guardianship. And so I would encourage you to take note of those. And if you have a child who you're not quite convinced guardianship is appropriate, or you just would like to learn more so that you can rule out the alternatives to guardianship, these are some really good resources for some free information on the topic. Okay, and as we are approaching 8 o'clock, I will say that we'll stop with my narration of the slides and let Sue ask a few of those questions.
Thanks, Joe. We've had a couple of questions about if there are co-guardians, there's an emergency where only one parent is present. How will that work?
It's going to be okay. If you're dealing with, say, like a medical decision where you have plenty of time to consult the doctors, they're going to want to know that the co-guardians are in agreement. But if it's an emergency situation, their understanding of the fact that uh, that these are special circumstances, and so this single guardian can make a decision. Now, if they make a decision that the other co-guardian doesn't agree with, that's a different scenario, and then in hindsight, we deal with that in the court. But this is not any different than if you have a 12-year-old who has to go to the ER and only mom is home, and mom has to rush the 12-year-old because dad is in Australia on business or something like that. Mom takes their child to the ER and calls the shots and has the authority to do that. Doctors are not going to wait for you to contact your co-guardian, AKA your other parent, who is in Australia and maybe not reachable. So it really depends on the circumstances, but if there is time and the ability to contact the other co-guardian, that's preferable. But if it's an extreme circumstance, then if there is one guardian who has the ability to establish their authority, they can manage things themselves. And we even see examples of this happening with like applying for benefits, submitting renewals through the county, also dealing with, say, like schools. If they're in a transition program, or even going to, say, like the program at Bethel University, a lot of times one parent or one guardian can make sure that things can facilitate, I suppose, and take care of things, while with the assumption or the presumption that the other co-guardian is in agreement with those decisions.
Okay. Should there be a secondary guardian for if the primary guardian dies unexpectedly?
Well, we do that in estate planning, certainly. When we draft a will, when we set up a supplemental needs trust, we're usually going to have a section on there where if the person, like say the testator of a will, if they are the guardian, this is their opportunity to identify who the successors would be. But in Minnesota, there is no such thing as a guardian in waiting like that. They simply do not appoint a person to be, at the ready to step in as the guardian. Um, Unless now there is a very rare exception to that. If you put that person through a court process and the judge determines that that court process was, not too long ago where they have to reevaluate. But that's sort of the downfall of that scenario, is that if you say, I want this person to be my successor, the problem is whenever we file a petition for successor guardianship to replace an aging parent, for example, well, that successor, that petition, the court still has to evaluate, number one, is guardianship still appropriate? But number two, is this successor at this time the most suitable person to be the guardian? So the idea that if you go through this procedure when your child is 18 and you've got another, daughter who's 25 years old, and you say, we want our 25-year-old daughter to be our guardian in waiting, the court says, no way, we're not going to do that. When you are no longer able to be the guardians, if your daughter wants to be the guardian, then she has to petition and we have to evaluate whether it's appropriate. If there is an emergency, like let's say mom and dad are in a hot air balloon accident and we need to have a guardian appointed quickly, there is an emergency procedure. We can file a petition explaining why it's an emergency, and if we file that petition to have an emergency guardian appointed, by law the court is required to fit us into their schedule and hold a hearing within 5 days. That emergency appointment lasts for a period of up to 60 or 90 days generally, by the end of which we are supposed to have filed a petition for full-term guardianship. But there is an emergency procedure if something unexpected happens to the appointed guardian.
Joe, someone wants to know if a family lawyer could properly set up a guardianship, power of attorney, supported decision making, etc.
Sure, they could. Question is, do they know what they're doing? This is I guess that's the question for all law. I often tell people, our profession is, I like to compare it to being like a car mechanic, where anybody can fix their own car. There's nothing saying that you can't. It's just, do you know what you're doing? That's the same with the law. As lawyers, there's nothing special about us other than we have, a knowledge and understanding of the statutes and how to apply them. I guess where the difference is, if we're licensed to appear in court, of course, but that's not specific to any court. I could appear on behalf of clients in bankruptcy court tomorrow, but I don't really know anything about how that works. So I wouldn't be the best person to hire for that procedure. So it really is just a matter of, first, I understand if you have a trusting relationship with that attorney, your comfortability with that person, but then just really making sure, do they understand how to take you through this process so that there are not mistakes made that, because you're talking about a major decision here. This is a significant life event for your 18-year-old. And so you want to make sure that you invest and do it right. Yeah, it is something that I talk about when we get to the hearing itself. My goal is that that hearing is anticlimactic, meaning if we've done everything correctly as your lawyers, then we're going to get to that hearing and the judge is going to see that everything has been filed correctly, that all of the information that they need is there to issue the court order without question. And so if that hearing lasts 5 minutes and the judge says, I have no concerns, I have no questions, everything, all of the statutory requirements have been met, I'm granting guardianship. If that's what happens at the hearing, we know we've done a good job. So the question is, if you hire a lawyer whose specialty is family law or anything else, do they know how to get you to that point?
Okay. I know we have multiple questions, but we've got a hard stop as close to 8 as we can make it. So, one question about what is the next step? If the person will be 18 in December and everyone is on board with this process, my assumption would be to reach out to an attorney.
Right.
And
Yep.
and then there was one more. What happens or should be done if there isn't 3 months until a person's 18th birthday?
You mean if the time frame is shorter?
Yeah.
Well, you petition as soon as possible. In my experience, uh, we do have that happen a lot. What I've experienced, if you're dealing with like doctors, if you're dealing with schools, if you're dealing with like the county in terms of applying for MA, is that if you can show that you have filed a petition and that you have a hearing date set, a lot of and basically that this is going to be uncontested, nobody's going to object. A lot of them are okay with recognizing your authority while it's in process because they understand that you don't have any control over how long the court process takes. The other thing is what they're really concerned about is their own liability, right? So if the school would be concerned that if they disclose information about an 18-year-old student, is that 18-year-old going to turn around and sue them? Yeah, so if you have a petition filed, if you have a hearing scheduled, that really eases their concern about their own liability. So my answer to that would just be get it done as soon as possible, but don't panic if there is going to be a period of time after the 18th birthday that before the guardianship appointment occurs.
Okay. Great. If folks still have questions that didn't get answered, Jamie posted my email address in the chat. You can reach out to me and I will track down the answer for you. But we've got a hard stop now. Thank you, everyone, for joining us tonight. Joe, once again, thank you as well. And good night, everybody.
Thank you, Sue. Thank you, everyone, for attending.
All right, thanks, and thanks to our sign language interpreters, and good night, everybody. With that, I'll end tonight's webinar.